Now, the US Supreme Court barely 24 hours ago ruled that states may compel online retailers to collect potentially billions of dollars in sales taxes. Now, that decision undercuts an advantage that many e-commerce companies have enjoyed over their brick-and-mortar rivals for the better part of a decade now. It was a close vote, though, 5-4. The justices effectively overturned a 1992 precedent from the very same court that had barred states from requiring businesses with no physical presence there, like out-of-state online retailers, to collect sales taxes. Now then, if you've been following the debates on how to tax tech giants, including e-commerce firms, both in Europe and in some African countries, this ruling is going to be an interesting reference point. Kenya, for instance, left that debate wide open in the replacement income tax bill drafted in May. So let's talk about this ruling in a bit more detail. Daniel Rangers joins us once again with more data on this. Daniel, at face value, this ruling seems to take away a big advantage that online retailers used to have over their brick-and-mortar counterparts. But is that really the case, or is that advantage being overstated?
No, it's a pretty significant advantage. So imagine if you're looking for a product online. Let's say it's a new tent. You want to buy a new tent, and you see this. You look at all the online reviews, and you decide, that green one's the one for me. You then go online and you see a bunch of different prices. Well, you're going to shop around within some of these larger retail constructions by Google, Amazon, or even eBay, and you're going to find which price suits you the most. And invariably, the one that suits you the most may be the one that is from a different state. And the reason for that is that might be a fairly small operation that doesn't have a brick and mortar or indeed a business presence in your state. Therefore, they get over paying the sales tax. That gives them the slight price advantage, which makes you go click and decide to buy from them instead of the one that does have a presence in your state.
Indeed. So how then does this, at a macro level, how does this ruling change the landscape for e-commerce in the US, given that it trashes this fairly fundamental idea that a company has to be physically present within a defined geographical area for certain kinds of taxes to apply on it?
Well, actually, I think one of the biggest impacts will be on small businesses that have kept their businesses fairly defined. So, for example, you might just have a business that sells online tents. In that instance, that small business has been able to have this little advantage. Now, some of the bigger players, like some of the big box stores, can offer the advantage of very good delivery options, the fact that the website is all contained very nicely. You don't have to give your credit card details out to some small company in some obscure other state. So actually, it means probably that some of these smaller businesses will go out of business as a result, and some of these much larger brick-and-mortar traditional retailers, I think, will now have the advantage because they have the economy of scale.
Indeed. For context, though, walk us through the reasoning in the last precedent-setting case, the one in 1992, on how digital sales should be taxed. I believe that was a Quill versus North Dakota case. Why did the Supreme Court at that time go with this physical presence argument to determine what and who should be taxed?
Well, the meta-narrative of the Supreme Court is usually related, and not always, but usually related to the difference between what the country as a whole does and what states are allowed to do. And traditionally, because of the history of the United States, they've given states' rights a lot of precedence so that states feel that they have the power to set their own policies. This is something enshrined in the US Constitution. But in that case, at that time, e-commerce wasn't a big enough deal. There was a lot of mail order, but it wasn't that big a deal. So essentially, the Supreme Court took the position that it would be better for states to set their own tax policies rather than have this sort of interstate system that would allow states to be able to compete against each other and benefit the consumer. But lo and behold, we live in a completely different world now, where online retail is so dominant that it has a dominating impact on commerce as a whole, and it represents billions of dollars of lost tax revenue for states that are in any case struggling to raise revenue because of the economic reality or the political reality that any person that wants to get elected and says they want to raise sales tax gets instantly pushed down, even if there are pending infrastructure needs in each individual state. So this is an opportunity, I think, for those states to raise a little bit more revenue in a way that won't impact the ballot box.
Indeed. I'm really tempted to ask you why the US just doesn't deal with the tax arbitrage that comes up here with just having a single VAT rate across the entire country. But I am pressed for time, so I'm just going to ask one last question. Are there potential loopholes that retailers, at least the large e-commerce ones, can use perhaps to sidestep this problem and retain that pricing advantage? Or is this a solid roadblock against any such tax avoidance measures?
I think there will be rogue retailers, especially, for example, in some of the more independent-minded retailers that make out that they're just producing a small number, or they're just selling some, out of convenience because they've got too many, sort of almost like disguising themselves as domestic as sellers of products. But on the whole, most reasonably large-sized retailers will have to invest in compliance software. And once they invest in that software, then it will become a much more routine tax collection operation. But in the meantime, you're going to hear a lot of moaning, a lot of complaining about the extra cost that they're going to have to do to comply with this. But I think fundamentally this is probably now baked into the system. But because of this states' rights issue, we could also expect there to be some legal challenges ahead. But I think most companies now will invest in that compliance software, except that they have to take tax here, there and everywhere and adjust their businesses accordingly.
Indeed. We'll have to leave it there for the time being. It was good talking to you, Daniel. Thank you very much for the update.